She said, I am not one to be played with. Watch yourself.
I'm not going to not fight this. I'm going to take this wherever it needs to go.
They tried to break into the back patio door. What would they have done if my children were upstairs? Do you think I'm gonna live in fear? It's not fair that I have to live like this because she didn't get what she wanted.
Plaintiff Megan Dew claims her former landlord spent her security deposit on pricey home renovations instead of returning it as required. She's suing for $2,100. Defendant Nicole claims the plaintiff threatened her. She says she owes nothing.
Please raise your right hand. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Good morning, Your Honor.
Morning, Naj.
This is case number 064 on the docket, Dew versus Parada.
Thank you.
You're welcome, Judge.
Let me see here. We have the plaintiff, Megan Dew. You are suing the defendant, Nicole Parada, for $2,100 for failure to return the security deposit. Yes. So let's start with you, Megan. What is your case?
Good morning, Your Honor. I would like to first start off by saying I'm a UNLV student in college. I'm missing my college classes, and I'm also missing both of my jobs today. In 2017, I met Nicole when 3 of my friends and I rented her home. We rented that home for 3 years, and throughout those 3 years, we've had nothing but perfect interactions. On May 31st, our lease was terminated, but Nicole was gracious enough to allow me to stay until the 2nd of June because my new rental property wasn't available until then. So come July 2nd, I reached out to Nicole. If you look at Exhibit B, these are the text message exchanges between us. I had reached out to her inquiring about my security deposit. And when she responded to me, she responded that my security deposit was $32. And if you look, I had responded to her, I was like, $32 out of $2,100, and she sent me the itemized list, which if you look at Exhibit C, these were the deductions that she had taken out of the security deposit. Immediately after looking at the list, I knew that some of these charges for sure were not just, and also I was just blatantly blown away by the fact that she could have taken out over $2,000 from the security deposit, because in the 3 years that we lived in her home, the home was kept in such good shape.
Your Honor, everything in the backyard that was alive was now dead. Dust was hanging from the vents. It is not the condition that they moved in at all.
Are the damages that, from your pictures, you say these are damages, are they beyond the, quote, normal wear and tear?
It states normal wear and tear versus damage is with negligence and carelessness. They didn't even so much as clean the house, let alone deep clean or pay a maid or even make an effort. It was pure carelessness and negligence. You could look at the pictures for yourself.
We stood in that home on the 1st of July when I was in the middle of moving things out, and she stated directly to me, you can hire a cleaning company if you would like. However, your deposit already contains a cleaning fee, and I am going to hire one anyways. So after that point, I reached out to a lawyer to speak about how I go about disputing the itemized list that she had sent. And when I spoke to him that following Monday, he said that I wouldn't even need to dispute the things in the itemized list because pursuant to the Nevada revised statutes, which is Exhibit K in your file, she was past due the 30 days that she was even allowed to return my security deposit. And if you look at that exhibit, the highlighted portion, subsection 6, it states that if the landlord fails or refuses to return the remainder of a security deposit within 30 days after the end of a tenancy, the landlord is liable to the tenant for damages, A, in an amount equal to the entire deposit, and B, for a sum to be fixed by the court of not more than the amount of the entire deposit.
Your Honor, in Exhibit D and E, she said...
Well, let me see that. Hold on. Okay.
She said, Nicole, I am not one to be played with. Watch yourself. Now, I'm not sure how to take that otherwise as a threat.
What about this language from you, Megan, where you say, and Nicole, I'm not one to be played with. Watch yourself, ma'am.
I understand that doesn't sound the greatest. What I meant by that, I would like to first go back to the previous one where it says, no problem, you can hold on to that for now so that one single check is printed. She wanted to send me the $32 electronically, and the law also states that a check needed to be handed. So I told her that I wanted the $32 put into a check. If you look at Exhibit A, this is the $32 check that I received from Nicole on the 29th of July. It is dated for the 24th of July, which is exactly 53 days. That is 53 days past her limit of my termination date. So the law states that she only has 30, and I did not even receive this check until 53 days passed. At that point, we were advised to move forward since she disputed my letter with a official small claims dispute letter, a letter of action. I sent that to her on the 12th of August. At that point, she responded back to me on the 16th in a letter where she basically stated, which I would say more is of a threat, that if I continued forward with this suit, she would then countersue me.
Nicole, what about that?
I want to be completely honest that I am shocked that we even made it this far to go to court. We've never had a problem. We've had fine interactions until it got to the end. A little backstory. I had that house for 10 years now. I bought that at 25 years old. I saved everything I had to get that house. That house was my first baby. That was my pride and joy. I was so proud of that house. We started a family, so I purchased another home. I didn't want to let go of my first baby, so I rented it out. She lived there from 2017 to 2019. Never an issue. I took on the task of managing it myself with Megan. We had fine interaction. I set up a bank account. She would go deposit the money. The rent was not paid on time for the next 6 months. Once I brought it to her attention, she did pay the late fee, and that issue was resolved. And then the lease was supposed to be up the end of April, but because of everything going on with the virus, she asked, and we all had working difficulties with their jobs, she asked if she could stay until May. Okay, with everything going on, you could stay till May. So that's April and May. She had a discount. I discounted the rent each month. So she already stayed 2 months with a discounted rent and an additional month past the expiration of the contract.
That was a suggestion from her. I didn't ask to pay less at all. I asked her if I could break up the payments. So she was the one who offered the $1,200, and of course I took that because we were both at the time waiting for our unemployment.
That end of that month comes, she's not ready still. She wants to stay a couple more days. Okay, it's $100, this is the fee, because I already had appointments lined up to start painting and stuff. She actually didn't vacate the property until June 2nd, almost at 8 o'clock at night. Okay, time goes by, I have painters, landscapers, I'm in there cleaning myself. It took me almost a month and a half to bring the property back up to how it was to even think about wanting to sell the property. So she texted me, as she said, I responded right away, here's the money. She declined. She said, no, do not send it back, I would like one whole check. So I offered, she declined.
When I saw the itemized list, I figured she took my deposit, which I had suspected could potentially happen. I believe that she had took my security deposit to fix up her home ready to sell. And what I mean by that is during my entire last year at the property, she contacted me about 2 times asking if I would move out of the property early and that she would get me a moving truck. And both times I was in the middle of my semester. I was like, I do not have time to go get a new, look for new places and then go move out in the middle of a semester. So when April came, and like she said, my lease was up in April, and I graciously asked her if I could stay because I was also out of work, just as she was during the pandemic. Now, back to that text message, basically, I had suspected since I moved out that there was a money issue and that somehow my $2,100 security deposit would be used to fix up her home. And once I saw that list and I know the state that I had left her home in, that is exactly what I suspected. And basically I said, I'm not one to be played with, meaning I'm not going to not fight this. I'm going to take this wherever it needs to go.
You said your house was broken into.
Yes, my house just gets vandalized. My window happened to get broke. They tried to break into the back patio door. They busted out the frame. That was just a coincidence, or did that happen from that threat to watch my back?
There has to be some evidence that she was the one that did it. In fairness, I know you were in the middle of a dispute with Megan, but did you file a police report? And secondly, is there any evidence? Because that's besides the security debate, that's a pretty serious allegation that someone broke into your home. Do you have any evidence
Your
of
Honor,
that?
I've lived there for almost a decade. I've never had the police come to my house. I've never had an issue. It's not a coincidence that someone says, watch your back, and someone breaks into your house. I have small children. I had to spend thousands to get security cameras for 2 of my homes. Do you think I'm gonna live in fear that someone threatens me because she didn't get what she wanted, then she broke into my house, tried to break into my house? What would they have done if my children were upstairs? It's not fair that I have to live like this because she didn't get what she wanted. Your Honor, you have the pictures.
Was there a police report?
Yes, it's Exhibit B.
Okay, let me, hold on.
And her name is at the bottom of the person of interest.
On July 3rd at approximately 1400 hours, returned to the residence to find damage to the rear sliding glass door frame, broken bathroom window, that you believe that the former renter is the one who did it. Okay. Admittedly, there seems to be no evidence at this point other than that.
Oh, Your Honor, I have
it certainly
evidence.
raises that statement. What is your evidence? Tell me.
Okay, I received a text message on the 3rd of July from Nicole's realtor. He had texted me stating that, I know last night you vandalized Nicole's home. And I also know where your new address is and where you work. I'm guessing implying like he was coming to get me. Now, when I received this text message, I was in Utah. I had left the night before to go spend the 4th of July in Utah with my family. And if you look at Exhibit J, these are my 2 bank statements from Utah. So I was nowhere near Las Vegas or Nicole's home when the suspected vandalism happened. And also, I would like to point out that to this day, I only know the vandalism from her realtor. I have never been contacted by a single police officer or a detective, and nobody has reached out to me. And like I said, I was in Utah, and I'm only hearing about this from Nicole for the first time.
Okay, there was no evidence that she was the one. You know, I can't be sitting here saying you broke into her home when there's no evidence that she was the one. And the evidence in Utah, the receipts from the credit card, spending money there, a couple of bucks in Utah on 2 separate occasions there. So the evidence is such that she wasn't there, no evidence that she broke in, and, you know, that would be a criminal case beyond, so that's not at issue. Now let's get to the part about the security deposit. I admit this is getting to be very technical because the law clearly states for a landlord to hold on to a security deposit or any part of it, the money has to be returned to the tenant or whatever money is due, and any money that is withheld of the security deposit there has to be an attachment of exactly what the damages are that the landlord is withholding the security deposit within 30 days. Let's look at the pictures that were submitted in terms of what the defendant is claiming is the damage.
Yes, Your Honor, please.
Okay, this looks like it looks like it's coming from the dryer.
Yes, in
which
the laundry
I imagine
room.
I imagine if you detach a dryer.
At what point in the itemized list does she state the dryer?
I didn't charge you for that, but there's like a whole bottle of laundry detergent and it stained the whole floor.
No, this has to do with the cleanliness. Yeah, this has to do with the cleanliness. Here's what I'd like to say about this.
It was filthy.
So, okay, did you decline the payment or did you just ask for a check?
I asked for a check. I told her to hold off for the Zelle payment and print me a
didn't
check.
decline the payment.
And she did print me a check.
You can hold on to that for now.
Check on July 24th, 53 days after the 2nd of June when I terminated the property. So we have the physical check that she got from a bank with the date at the top. And it says July 24th.
This is a technicality of the law, but the law. The security deposit must be returned in 30 days. Any part of it that is not returned, at some point, there has to be the itemized statement for why you're not returning the whole amount. I think I really understand this. You lived in that house, I think you told me you lived there for 10 years. So your heart is invested in this place. And anyone who's owned a home for a bunch of years, you've got memories there. You picture that house as it was when you lived in it and all your memories there, and it was a certain way. And so therefore, when you rent it out, when you've got other people there, their lifestyle could very well be different. That is, even if they're the neatest people in the world, oh man, look what they did to the kitchen. I can't believe they turned this bedroom into an office and they nicked the walls. I mean, that is a very normal reaction of anyone who rents their own home. Not just rental properties that you invest in, but a place where you lived, which was your home, and you rent it out, suddenly you're going to be disappointed anyway. That's a given. Now, the plaintiff lived there for 3 years. There's going to be wear and tear, but let's talk about that 30-day time that the security deposit has to be returned. Even though the discussion started on the 30th day with that text from the plaintiff saying, hey, what about my security deposit? And the defendant then said, well, I'm going to send you, or how about $32? The point is that the money wasn't returned within 30 days. In fact, let's be honest, if she hadn't texted you that day, we wouldn't even been talking $32 yet. So based on what the law is and the fact that the money, in fact, was not returned in 32 days, even the $32, I'm not even talking about the whole security deposit, I fine for the plaintiff in the sum of $2,100. Megan, what are you going to school for?
I am a biology major at UNLV.
Because I was thinking you were going to become a lawyer.
Oh, maybe someday, right?
Yeah. And both of you, by the way, well-argued cases. Oftentimes in a small claims court, we have people that are very concerned about their point of view, but didn't do the preparation that both of you have done. So this was as well presented as anyone I've had before this court. So a great job.
Thank you.
Just disappointed that she gets to ruin my house and then still get her money back like nothing ever happened.
I knew my stuff. When Nicole said that I wasn't one to play with, yeah, that's exactly what I meant. So I am completely happy with the judge's verdict.
Hey YouTube, thanks for watching. For more Judge Jerry, click here. For more Jerry Springer, click here.